Everyone, good morning. I'd like to join Mr. Morrison in thanking you all for your service. I know it's been a relatively long trial. We went a little bit longer than we had anticipated, but one thing that we noticed, throughout the entire course of the trial is that you guys all paid attention. You took the testimony very seriously. You paid attention to it. And on behalf of Jeff Muller, the victim, on behalf of the state, we want to thank you for that. I think I told everybody in the opening, might have been one of the first things that I said to you, that this case reminded me of a quote from Mark Twain, that truth was stranger than fiction. And I quoted a colleague that said, you simply can't make this stuff up. And as you've heard the evidence in this case, you've learned that this defendant confused a pet store owner from Newton, New Jersey, with a money broker from Mawa and kidnapped the wrong person. You heard that this defendant joined a chapter of the Hells Angels Motorcycle Club that in actuality didn't even exist. And you've now heard that this defendant is trying to fully justify, completely excuse, and asking you, the jury, to completely excuse very violent criminal conduct based on a threat that, as it turned out, wasn't even real. These things are stranger than fiction. And I agree with Mr. Morrison. This is a unique case. It's a strange case. It's bizarre with several of the facts that you've heard. But when it comes to the guilt or innocence of this defendant, it's not a difficult case. During the defendant's testimony, he basically admitted to each and every element of every charge in the indictment. That really is not being challenged. It's not in dispute. What the case comes down to is a question of whether the defense of duress is applicable. Now, I think I also mentioned in my opening to you that there were 7 reasons that I anticipated that I would argue to you in a closing as to why the defense of duress is not applicable in this case. And based on the evidence, as we've heard it, I would submit that there is, in fact, at least 7 reasons why the defense is inapplicable. Number 1 is that this defendant joined what he believed to be the Hells Angels Motorcycle Club. He wasn't forced to join. Even by his own testimony, he said that he was asked by Billy Barger. That the family would appreciate it, I think, was the testimony. Now, folks, this is an important fact, because if you think about what the Hells Angels Motorcycle Club is all about, what we all know it to be about, it's about violence, it's about intimidation. That's what they do. I would suggest to you that you can't join a club that you know uses violence and intimidation to do basically their business, and then claim that your criminal conduct should be completely excused because you were subjected to those things that you joined. If that were the case, every member of the Hells Angels Motorcycle Club would be immune from prosecution, because that's how it's structured. There's somebody in charge of a chapter, they give orders, they engage in criminal activity. That's what they do. They're not immune from prosecution because they're a member. Now, the judge is going to instruct you very shortly that if you recklessly place yourself in a position where you might be subject to duress, the defense is inapplicable to you. It doesn't even apply. We don't even get to whether we disproved it beyond a reasonable doubt. It's simply inapplicable. because this defendant joined the Hells Angels Motorcycle Club, the defense is in play. There's another way that this defendant, the second reason, where he recklessly put himself in a position where he might be subject to duress. Folks, think back to the testimony of how this all started. It started in a bar called Evans in Nevada, Missouri. And it started out really as a conspiracy between two people, Roy Slates and this defendant only. They were talking, they were drinking in a bar. Roy Slates told this defendant his tale of woe, how he had lost this money. And this defendant, who was now starting to get involved with this Hells Angels chapter, knew about Billy Barger, knew what he was all about. He told Roy that he had a solution. It was this defendant who brought the whole idea of retrieving this money to Billy Barger. It was this defendant who did that. What did he expect was going to happen? They needed money for this bar. You heard some testimony about that. Billy Barger needed money. This defendant was behind on his mortgage payments. There was a lot of money at stake. And I agree with Mr. Barger. Billy Barger was probably counting money in his head. I think Doug Stangeland was as well. But the bottom line is it was this defendant who brought the whole idea of this to Billy Barger's attention. He was the one who got this all started. He was the one who initiated it. And folks, I would suggest to you that you cannot initiate a criminal event and then seek to excuse your conduct citing duress. Number 3, think about the threat. The threat was Sonny Barger, right? The Hells Angels, Billy Barger. When you think about it, the evidence showed that threat was not even real. Now, there was no Heartland chapter at the Hells Angels Motorcycle Club. Billy Barger was not related in any way, shape, or form to Sonny Barger. There could never be a threat from the Hells Angels. There could never be a threat from Sonny Barger. It was impossible. Neither the Hells Angels or Sonny Barger was actually involved. Now, I would suggest to you that to the extent this defendant maybe believed in that threat, that belief really wasn't sensible or reasonable. You see, and we go back to, and I kind of made a joke of this during the testimony, but it's really hard to grasp. Nobody here rode a motorcycle. Billy Barger didn't ride a motorcycle. This defendant didn't ride a motorcycle. Andrew Wadle didn't ride a motorcycle. He knew Billy Barger for 10, 12 years. Never saw him on a motorcycle. It's kind of rule number 1 for the Hells Angels, that you ride a motorcycle. Now, the only club he actually belonged to, Billy Barger, was the Shriners. He had known Billy Barger, his wife, family, for 10, 12 years. Never saw Sonny Barger. Billy Barger would claim that he could have 150 Hells Angels or 100, 200 at a moment's notice. Never produced a single Hells Angel, ever. There were flags. There were reasons why this defendant probably should have questioned whether Billy Barger was in fact related to Sonny Barger. He had a friend, John, from South Dakota, that he grew up with. Billy Barger told him that John was his cousin. John would have been related to Sonny Barger as well. He testified he had his phone number. All he had to do was place a call to John and ask. There were ways for him to find out. And I guess the point of this is, I would suggest to you also that before you can excuse criminal conduct, especially serious criminal conduct, like we have here, based on a threat, you should make sure that that threat is actually real. There were alternatives. The judge is going to instruct you that one of the things to consider in evaluating a claim of duress is whether a defendant had alternatives. Did he have the ability to go to law enforcement? Did he have the ability to escape? Now, Mr. Morrison quoted the Old Testament and the story of Noah, that this was like, the flood that he couldn't escape from. Noah actually did escape the flood. But unlike Noah, this defendant, he didn't have to build an ark and load all the animals onto it. He just had to go to the police. It's pretty simple. There were alternatives. Think about what Charles Stangeland did when he was afraid. What did he do? He left the area for a short period of time. He cooperated with law enforcement. That's how he dealt with it. Jeff Mueller, what did he do? Cooperated with law enforcement. They guarded his store. They guarded his home. These are all alternatives. The witness protection program, there are a lot of alternatives. There was no imminent threat to this defendant which prevented him from seeking out alternatives to this threat. Number 5, this defendant, and if you look at his statement, he described the threat to him and his family as light. That was the word that he used. He described the threat as something a kid would encounter on the playground. In connection with his home invasion and the kidnapping, there was never any physical harm to this defendant or anybody in his family. We're talking about words from Billy Barger. That's it. Just words. No one was actually harmed. So I would suggest to you that to the extent that there was any generalized threat from Billy Barger, it was not something that was overly significant, and it certainly was not imminent. The judge is going to instruct you that the more serious the crime, the less applicable the defense of duress. It's hard to imagine a more serious crime than we have here. This man was kidnapped. He was restrained. He was driven halfway across the country to certain death. The seriousness of the crime, as the judge will instruct you, militates against the duress defense. Finally, number 7 is, again, the immediacy or imminence of the threat. This defendant was 1,000 miles, 1,200 miles away from his alleged threat, Billy Barger. There was nothing imminent. There was nothing directly in front of him when he was in New Jersey, Pennsylvania, that required him to do anything. That also militates against the defense. Mr. Morrison, he somewhat compared what Doug Stangeland experienced to what Jeff Mueller experienced and what Charles Scannell experienced. And frankly, that was a little bit difficult to listen to because Doug Stangeland is not a victim. If you think about it, the difference is he engaged in conduct that caused great harm to other people. What did Jeff Mueller do? He showed up for work. What did Charles Stangeland do? He sat in his living room watching Monday Night Football. You can't compare what they went through to what he went through. I agree that this case impacted a lot of people in a negative way. It did. But it was this defendant's conduct that caused that negative impact. Now, Mr. Morrison didn't really dispute that the state had proved each and every element of the offenses beyond a reasonable doubt, but I just want to touch on a few of them. The first one is Mr. Morrison mentioned that this defendant never actually pointed a gun at the victim. And he's not charged with that offense. That's a separate offense for pointing a gun at another person. He's charged with possession of a handgun without a permit. Now, the judge is going to instruct you on constructive possession. It doesn't mean you never, to be guilty of possession of a firearm, you don't actually have to necessarily have it in your hand. You don't have to necessarily use it against another person. You have to have control over it. It was this defendant's gun. It was in the center console of his vehicle. He admitted he had control over it. Those are the elements of the offense. His purpose in possessing it, and he told you, was in connection with his kidnapping. That is the possession of a weapon for an unlawful purpose. Another thing I want to talk about is some sort of suggestion that this defendant's conduct was not as bad as Billy Barger or Monty Swartz. Billy Barger is guilty. Lonnie Swartz is guilty. This defendant is guilty. They are all equally guilty in connection with what they did. This defendant had a very significant role in this kidnapping. He was the leader on the first attempt when they came out. He was one of the leaders in connection with the home invasion. He was the one who was driving Jeff Mueller halfway across the country to a certain death. He had a very significant role. To say that somehow he was better than Billy Barger or Lonnie Swartz for that matter is basically like trying to decide which of the 7 deadly sins is better. Is pride better than greed? Is gluttony better than sloth? Or, they're all bad. It doesn't matter. Each person here is guilty, and they're equally guilty. The conspiracy to commit murder count. This defendant admitted to you. He knew Jeff Mueller was dead. Had he gotten to Clearfield, Pennsylvania, he was going to be handed over to the Hells Angels. Andrew Wadall told you that Jeff Mueller was going to be shot, wrapped up in a sleeping bag or a blanket, weighted down, thrown in the river. That's what was going to happen to Jeff Mueller. This defendant told you he overheard that discussion. There was talk of killing Jeff Mueller before they ever left. The thought that the answer was that the car broke down, this defendant had no control over that. It was by happenstance, sheer luck. You don't plan for luck. Had that not happened, even according to his testimony, Jeff was dead. He wasn't going to survive. Now, if you want to think about what happened at Rick's C-Store, this defendant said it was his plan to release Jeff Mueller. Why try to get the car started? He tried very hard to get that car started. Why tell the cashier that there's no need to call the police? He's just a friend. We're taking him to the mental hospital in El Dorado. If that is the solution, if that is the answer, don't you want the police to come? You wouldn't want to get the car restarted. The last stop was in, I think it was Kingdom City, and this defendant gave up control of the car at that last stop. If your intention was to let Jeff go, why would you give up control of the car? Doesn't make any sense. None of that makes sense, folks. The judge will instruct you that a first-degree kidnapping can become a second-degree kidnapping if the defendant releases the victim unharmed in a safe place. Jeff Mueller was not released. Releasing him would have been Doug Stangeland turning around, hey Jeff, you're free to go. He didn't do that. He relied, according to him, or assumed that Jeff Mueller would have the courage after all he'd been through. They had threatened the life, not only his, but of his wife. They said that they had somebody guarding his wife, and if he didn't cooperate, they were going to kill her. And he assumed that Jeff would have the courage just to bolt out of that car. When he never had the courage to stop, it doesn't make any sense. And even if that is the case, why tell Patricia Lodge, don't call the police? Doesn't make any sense. He didn't release Jeff Mueller. To the extent he did anything to lessen up his pressure, he gave up. The car was broken down. They were at Rick's C-store for several hours, or a couple hours. Help was not there yet. Rick's was getting busier, it was getting light out. They were caught at that point. He didn't let him know, but he was not unharmed. Jeff Mueller was beaten, he was battered. You saw the bruises, the black eyes, the abrasions. Physically, he was not unharmed. Emotionally, he was not unharmed. He will never, those scars, emotionally, I think you saw them when he took the stand. They were with him forever. Mr. Morrison asked, how do we make this right? And I agree with him again. There is no making this right. But this defendant should be held responsible for what he did. He committed a very serious crime against an innocent person. His only sin was he had the wrong name. The state proved each and every element beyond a reasonable doubt in the indictment. For the 7 reasons that I stated, the defense of duress simply does not apply. And we would ask that you find the defendant guilty. Thank you.
Ladies and gentlemen, what I propose to do is excuse you briefly and begin what we call the jury charge. We'll do that in about 10 minutes or so. Then probably have a break for lunch and complete the jury charge. I think breaking it up